Joining us to break this down is a criminal defense attorney, Vikas Bajaj, and addiction psychologist at UCSD, Carmen Polito. Good morning to the two of you.
Good morning.
First of all, this whole idea of affluenza. Give me your take on that as a psychologist.
Well, affluenza is not a diagnostic disorder, but I do believe that it might be a risk factor for some problem behaviors. And basically what we're saying is that or what the psychologist in this case said is that affluenza is just having the means and access to things that can produce risky behavior like alcohol or access to vehicles. That together with poor supervision and lack of consequences to the behavior.
But that's not even, it's not even recognized by most psychologists, is it or isn't it?
It is not. It is not diagnostic. No, it's just a concept.
Just a concept.
Just a term, yes.
But apparently a pretty good defense.
Well, that's correct. But you know, the DSM-IV and 5, this is sort of the Bible of all psychological disorders that are recognized in the field like Dr. Polito practices in. It's not recognized in that DSM-5. However, it is a viable defense. And what the defense team actually did here, they looked at this young man and found the one element that was most relevant that could have explained the behavior that led to this tragedy. And they presented that to the judge, and the judge weighed the materiality of that and said, you know what, this did in fact affect the behavior of this young man, and I need to entertain that. And I believe the judge did the right thing, because you have to understand, when we're talking about DUIs and fatalities, these are liability cases for the bench. And what I mean by that is there's not a judge in this county or a federal judge around the nation that's going to want to say, I'm going to give this kid a break. And the reason why is, if something like this happens again in the future, well, you can bet your bottom dollar it's going to be front page news on every media outlet in the nation, and probably worldwide. And judges don't want that liability. So for this court in Texas to say, you know what, I'm going to give a chance to the affluenza syndrome and this application of this young man speaks volumes for the materiality of this defense.
Yes, I have to, disagree with that, because I do believe that behaviors need to have consequences. And the interesting thing is that basically what it was put on the table was that the judge have to decide between punishing this kid or sending him to rehabilitation. And I think that both things are important and necessary in this case. They are not necessarily mutually exclusive.
He could have gotten 20 years in prison in Texas. That was the maximum. So, but is it not true what the poor father and husband said, that money won out here? What is your take on that?
I can't agree with that. What I can say is the family had the means to hire a defense team to explore the issues of what could be relevant for this kid's behavior. Obviously, it costs money, right? It costs money for the defense team to be assembled and to put together a viable theory. It costs money for the psychologist.
Yeah, but the bottom line is, if he didn't have money, he would have never been able to have this defense.
Perhaps, but we'll never know. I mean, we have court-ordered programs.
He wouldn't have affluenza as a case unless he was rich, right?
That's correct. Because of that specific application here, this is the trigger or the item, the most relevant thing that affected this kid's behavior. So you're correct. It applies to this case. It doesn't apply to everyone.
And I would have to say also that when you look down at the the kind of like systematic process that this child is claiming that was the cause of his behavior.
16 years old, lives in his own house.
So yes, like having access to things and not having people who are supervising him. These are things that are not necessarily of only individuals who are affluent. They can be like children that come from family from disadvantaged backgrounds who may also be poorly supervised, who may also have little consequences because their parents don't know what they are engaging in and don't necessarily engage in criminal behavior. So although I would agree that this kind of defense comes primarily because of the situation of this child having a family with money, it's not necessarily unique to people with money.
But it's generally a lack of control. It's generally a lack of control and supervision that can either show itself and come to fruition as a drug addiction or an alcohol addiction, or just not recognizing consequences for the actions. But let's not forget, the most important thing I believe in this situation with this young man and the fatalities that he unfortunately caused is a lack of intent. This was not an intentional crime. He intended the foundational acts, which led to him being under the influence almost 3 times.
He was drunk, though. He was drunk. He chose to drink.
That's correct, but he did not choose to take an individual's life.
I would have to say that, when you look at the behavior one at a time, You know, like engaging in drinking when it's illegal for his age, engaging in driving when he doesn't have a driver license, driving under the influence, which is illegal for all of us. All of those are illegal, intended behaviors. And then, unfortunately, the end result was something.
Great discussion. We have to go. We could go on with this. But the bottom line is, does he learn consequences from this?
If the rehabilitation is successful the way it's ordered, I believe the family is going to pay almost $500,000 for the court-ordered supervision and rehabilitation. If it works, he'll learn. Time will tell.
Do you agree?
I don't know. I don't think so.
Okay. Thank you very much. I appreciate it.